Hello, I'm Matthew Mazur. I'm a South Florida bankruptcy attorney, and today I'd like to answer the question, what is an adversary proceeding in a bankruptcy? An adversary proceeding in a bankruptcy is a situation in which a trustee or a creditor takes an adverse position either to the debtor or a third party with regard to an aspect of the case, such as the dischargeability of a debt, a transfer that occurred before the filing of the bankruptcy. For example, let's say you're about to file bankruptcy. Your mom had loaned you $4,000, and before you filed, you wanted to make sure you paid mom back, so you gave her the $4,000. During your bankruptcy, the trustee finds out about this. He's going to give you a choice. Either you can pay the $4,000 back, or the trustee is going to go after your mom in an adversarial proceeding to recover those monies. She is considered an insider, or it potentially could be considered a fraudulent transfer depending upon the facts. The trustee will then file the adversarial proceeding within the bankruptcy case and serve your mother, and basically a mini lawsuit occurs within the bankruptcy to resolve those specific issues. Another example of an adversarial proceeding is one in which a creditor objects to a specific debt, whether it is dischargeable or not, or whether there was fraud involved with that debt. And again, another mini type of lawsuit occurs within the bankruptcy to resolve those specific issues. It might be hearings, it might be a full-blown adversarial trial. It all depends upon the extent of the situation and how far the parties are willing to go to try to prove their right with regard to the dispute in question. As you can imagine, a adversarial proceeding in a bankruptcy is very difficult on both the debtors and the third parties that are brought into those proceedings. It is often a shocking experience for a third party to receive an adversarial notice in the mail or to have it served upon them, and only to find out that they're now being brought into somebody else's bankruptcy case. It is really important, if you're ever served with a notice of adversarial proceeding, that you take it seriously and that you seek legal guidance immediately. There is a limited time frame that you have from the time you received an adversarial proceeding to respond. If you don't respond timely, you could end up getting a default judgment against you, which would allow collection activities under that judgment. So bottom line, if you receive an adversarial proceeding, talk to an attorney as soon as you can to find out what your options are, what rights you have. I hope this information has been helpful, and check out the other videos on our page. Look forward to talking to you soon.